Objection to the Form. This is Justin Humphreys. Today we're going to talk crime and punishment with Grayson Cheek. Welcome to the show, Grayson.
Hey, thanks, man. I'm happy to be here.
Grayson, before we get into it, can you tell everybody a little bit about your practice and what you do in town?
Yeah, so I've been practicing criminal defense. I guess I got out of law school in 2008 and didn't really know what I was going to do. Joined a firm in Charlotte. And back then, Judge Ola Lewis was our senior resident Superior Court judge, and she told me day one, you're going to hit the ground running. And I started getting appointed pretty heavy felonies right out the gate. Fell in love with criminal law. I've done it for about 13 years now. I worked at David & Associates for 10 of those years and developed their criminal practice and broke off on my own close to 2 years ago. Focused, 80% of my business is private criminal defense work, and the other some personal injury practice.
Yeah, Judge Lewis was great. She swore me in as well, and I miss practicing in front of her. And I remember seeing you from David & Associates. And that's exciting to start your own practice. It can be challenging, but it's definitely a rewarding thing to do.
I had a wife that told me she'd rather me fail and do it on my own than to not do it, and so thank God I had her pushing me along.
So what types of I guess it'd be what types of cases are you handling as far in your criminal practice?
Something as rudimentary as a speeding ticket. A lot of times that's my first impression with the client. That's the most common offense. A client gets out, you do a good job for them. I really don't like doing speeding tickets because there's no real value in it. You kind of go in and it's a machine. But you do a good job there, and that turns into them calling you down the road really for anything. And I refer out to other attorneys, other stuff. But anything from that all the way up to attempted first-degree murder is about as high as I've gone. I've had some inquiries over the last couple of weeks about some murder defendants. So a lot of drug defense, DWI defense, anything in between.
Yeah. That sounds pretty high pressure.
It's fun, man. Sitting in a desk all day is not my jam. I like to be out in the courtroom. And so anything that can get me there, I'll take.
Well, I appreciate you coming on. And one of the reasons that I wanted to have you on is to talk a little bit about the way the criminal court system works and sentencing in particular. And I think it's kind of a area that most of the public doesn't know quite about. And frankly, a lot of attorneys don't know about it. I don't know as much about sentencing as I should. So I'm kind of looking forward to learning a little bit today and interested to hear what you have to say. One of the things that kind of where I wanted to start with it is discussing sentencing guidelines and what that means and how that operates, because I think a lot of people don't understand how punishment is kind of handed out through the courts. Yeah,
so if you go into court, if it's your first impression in court and you're charged with a felony, you're going to hear a judge tell you day one, look, you're charged with Class H felony. The maximum punishment you're going to get for that possibly is 39 months in prison. In all reality, if this is your first time in court, that's not going to happen. But we're versed and told, really ethically, we need to tell the clients what the possible maximum punishment is going to be. The judges are confined to a set of guidelines, whether it be misdemeanor sentencing or felony sentencing. And so every felony or misdemeanor is enumerated with a class. Felonies from B1, A, which would be your first-degree premeditated murder, all the way down to a Class I felony. Misdemeanors, Class A1, 1, 2, and 3. And as you offend multiple times and accumulate sentencing, what we call points, is like, hey, this is your second DWI, now you're a level 2. You get some more offenses, you're level 3. Now we travel along this chart, if you can envision it, it's just like a block grid. And so your punishments as a first-time offender are going to be less than they are as a level 5 offender, and they're more severe the higher up the chart you go.
And so I guess conceptually how you'd picture it is the higher the letter, the more severe the offense would be.
Yeah, if you're thinking about it alphabetically, starting with A, it's a block you don't want to be in.
Yeah.
Yeah.
Yeah, and that makes so then you've got that's one end of the block. What's the other end? Is that your accumulation of points or your priors?
It is. So as a level 1 offender, and which is probably something we'll talk down in the podcast about. That's where a lot of times you're going to be offered maybe like a deferred prosecution or a conditional discharge, where you could potentially get that sentence turned into a not guilty or a dismissal. And so you start out at level 1. You and I are born with 0 sentencing points, and at some point we may accumulate 1, and then we start to travel along to the higher offending class, which is going to be a level 6.
Do sentencing points work kind of like driver's license points or insurance points, where they'll go away over time?
If only they did. They don't. The only way foreseeably you'd be able to get a sentencing point off of your criminal records if you got it expunged. Well, there are some offenses, if you've been found guilty of, you can have expunged, depending on your age or the type of offense. Then those points would fall off because there would be no record of that crime. But yeah, no, those sentencing points are going to stick with you.
How much latitude or variance are there in the typical blocks on the grid, as you've put it? Like, I guess kind of the point of what I'm asking is, how much discretion do the judges really have when they're deciding within the type of crime and your prior criminal record?
Yeah, so that is it's all defined by the sentencing guidelines. On low level Class I felony, first time offender, the judge is not going to be allowed to give you an active sentence out of the gate. You could go and represent yourself and say, hey, I'm guilty of felony possession of marijuana. I've never been in trouble before. And no matter how upset you make the judge, short of contempt of court, he or she cannot put you in custody. It's a C, what we call a C block. There's a C, an I, and an A assigned to certain blocks. A C block means it's community punishment. You cannot go to jail. Now, if you violate your probation, you can. But heading out, that you're not going to jail. And so the judge is confined to a non-active sentence there, whereas in an intermediate block or an active block, then the numbers are laid out for them, whether you're going to be in a mitigated range, presumptive range, aggravated range. And so they have to sentence depending on mitigating factors or aggravating factors, or if none are filed, confined to the numbers that are in that block.
So that's something I kind of wanted to get into, was the CIA, and it's not CIA like the Central Intelligence Agency, but I'm talking about on the sentencing guidelines. What does it mean if you have those letters in the block or the sentencing guidelines?
Yeah, so in those blocks where you have a C, an I, or an A, a judge is allowed or to sentence you either to a community punishment like unsupervised probation, an intermediate sentence, which would be the next level up. And that would mean typically like a 30-day active split or some short active term.
And so when you say like an active split, what does that mean?
Yeah. So let's say level 2 offender got caught selling heroin. They're in the presumptive range, looking at the minimum in an intermediate block, like a 12-month and up. And so if the person if the agreement was to put them on probation and it's an intermediate block, then maybe they have some credit in jail before they bonded out, which could be 1, 2, 3, 4, 5 days. And the judge could say, hey, your intermediate punishment is going to be 5 days credit for time served on a split. So that's just an active component of a suspended sentence.
So is it like community could be probation or community service, and I guess active means you're in jail.
Active means you're in jail.
And so then the intermediate means you're doing both. You're doing some community service or some probation, and you're doing some active time.
Typically it's some active. That can be worked around with some intensive supervision or some other component that's higher than regular probation.
Is that like house arrest?
Yeah, you could do that. I always get the question, hey, like I'm looking at an active sentence.
Yeah.
Man, can I just do it at home?
Yeah, that seems like that'd be a lot better.
I get that question a lot.
Yeah.
And the answer is really no. If you fall into a block with an active sentence, and at least, I guess I should preface this with, typically when I'm pleading a client, I have all of this worked out beforehand.
Yeah.
And the judge doesn't have a lot of discretion to move from what I have worked out from a client. So they know going in what they're looking at. I try to leave it open only for a judge to either accept or reject the plea. And if they reject the plea, then we're going to recalendar it and put it in front of somebody else.
Yeah. Well, I guess going back to this house arrest thing, are there situations where you're on house arrest after plea or conviction, or is house arrest kind of a bail type situation?
So prior to it might have been January of this year, your house arrest is typically a condition of pretrial release, where, hey, we're going to put you on a GPS monitoring bracelet to make sure that you're not acting out or being in places where you're under your curfew. And I think it was about January this year, probation has received what is called delegated authority, and they can kind of on their own volition put you on a bracelet for 30, 60, 90 days to track you without a judge ordering that. And so now there's a little more post-conviction usage of a monitoring device.
But so that could be part of your community sentence, that I guess in a way it's not considered an active sentence, but some probation officers have the discretion to put you on an ankle bracelet to monitor you.
I think too much discretion.
Yeah, that's something else. I wasn't aware of that. And so I guess you mentioned intense supervision. So how does that differ from a house arrest situation?
It's kind of the same. So the EHA, electronic house arrest, and curfews and all would qualify in effect for intensive supervision.
What about the situations where you have somebody that's committed a drug offense or an alcohol offense, and they're looking to do inpatient treatment as a substitute for active jail time? How can you arrange that for somebody?
So the statute provides for that. A judge can credit day for day, and I'm sure you. I don't remember if you and Jimmy McGee talked about that or not. Probably so, but so on an active component of a DWI, say the judge can credit day for day an inpatient alcohol treatment program against an active sentence. And so on a level 5 DWI, and there's so many nuances in sentencing. So like DWIs are sentenced under the old sentencing laws of fair sentencing, where if you get a 60-day sentence on a DWI, you're going to do half of that. And so if you do 30 days inpatient on a level 5 DWI, then really the judge can say, hey, you've given me credit for time served in inpatient treatment. There's no probation or anything. Now, outside of DWIs, everything else is sentenced under the structured sentencing, which is where these guidelines come in.
Oh, so if you've got, and that's kind of, I was aware of that in the DWI or the DUI context, but I was not aware if you were charged with a drug crime, if you could go to rehab and then come to the court and say, look, I've gone to inpatient. Can I count this towards my sentence?
Absolutely. And I'll tell you, I had a client in the last 3 weeks where he got charged with DWI twice in about a week period.
That's a rough week.
It was rough, yeah. And there weren't really any defensible arguments. So I didn't have a motion to suppress available to me. He'd gotten in 2 accidents. There's really a reason for the stop. And I mean, he blew like a 22 and a 21, and both in the respective DWIs. And so what we did is put him into inpatient treatment, a very long-term one. And the way that I pled the 2 cases, this is why it's so important to understand in sentencing. A first DWI, you're looking at level 5,
yeah,
and you can get 24 hours of community service and no active time. A second offense, if you have you look at your grossly aggravating factors on DWIs, and he had a revoked license, and he would have had a prior DWI conviction, even though I pled it just a minute prior.
Yeah, and
so he would have been looking at a level 1 and would have had to do 30 days active. The way that I structured the plea was I pled to the second DWI first. And so he had a revoked license due to an impaired revocation, which is a grossly aggravating factor. And so he got a level 2 DWI, which is a 7-day minimum sentence. And then I pled him to the first. And so now he has a grossly aggravating factor for a prior DWI, but he didn't have a revoked license at the time. So we took what could have been or would have been a 31-day active sentence and put it to 14. And he got credit for all of that inpatient, and he's on probation.
And it's crazy how just the timing on something like that can make a 2 to 3 week difference in somebody's life.
Totally. I've seen other attorneys do that same plea just in reverse order, where the guys or the defendant's now going to do 31 days in custody. And I pulled him aside and like, man, you might want to appeal that and change up the order because you can get him out in 14.
Yeah. We'll get a little bit more into detail into this, talk about some ways you can kind of be creative with pleading and sentencing, and get a little bit deeper into the guidelines. And we hope to hear from some of the audience today. If you want to give a call and ask Grayson some questions and talk to us about crimes and punishment and sentencing, give us a call. The number is 910-299-7535. All right, welcome back. We're still here with Grayson Cheek, and what I'd like to do in this segment is explain to everybody how a typical plea negotiation works. And, I realize that probably looks different if you're in district court, which would be your misdemeanors, or in felonies, the felony court, superior court. I know you do both, but I was hoping you can kind of take us through that process as far as how you deal with pleading a client if you've determined that this isn't one to take to trial.
Yeah, so I think we'd probably talk more about the serious offenses here because that's where we kind of get the negotiations going on early. We're always considering the sentencing chart because it enumerates where there's an active sentence, like we were talking about, in an A block, where there's not the option for an intermediate punishment or probation. And so if I have a client that's charged with robbery with a dangerous weapon, and it's a Class D felony, even as a Level 1 offender, or say shooting into an occupied dwelling, a Class D, as a first-time offender, if you're found guilty of that, you're looking at a straight active sentence, and somewhere in the range of 5 years. And so my job is to, in the negotiations, go to the DA and say, is there a way that we can get this client from this D block to a lower offense? And there are ways to do that, which would be changing it up to say shooting into an unoccupied dwelling, or an attempt. If it's a non-drug offense, an attempt would drop the sentencing level one level.
So kind of stepping back from a big picture perspective, it's my understanding that your typical felony case begins in district court, and that's where there's typically some negotiation on the pleas. Would you say the majority of your felonies that you plea resolve at that initial stage in district court?
Different counties are different, in how it's handled. Your lower level felonies, your H's and I's, are, I would say, the bulk, 60, 70% are handled in our felony district court, which has been going for years here in New Hanover County, run for years by Holt Trotman, who retired earlier this year. Brunswick County just started with a felony district court this year, and it's running well. It's taken our caseload there down tremendously, where I would have at times 40 defendants on a Superior Court calendar for case management. Now I'm down to maybe 15. And so those H&I level felonies, or even the ones that are a little higher, where we're able to negotiate a plea into the H&I level, we can do that in district court now. It moves a lot easier.
I see. So you're saying it's only the low-end felonies that go to district court first?
Well, where we can dispose of them in district court. So every felony, every charge in North Carolina, with few exceptions, originates in district court.
Gotcha.
And the proper jurisdiction for a felony is Superior Court, but you get to Superior Court by way of a finding of a true bill of indictment by the grand jury. So the case is made to the grand jury, and they say there's enough evidence here to bind this person over to Superior Court. So here's the indictment. Now you're properly in Superior Court. The defense attorney can speed that along by waiving probable cause and saying, just take me on up to Superior Court. But if you're a lower level felony, we try to filter those through our felony district court, so to ease the load in Superior Court, to really kind of focus in on cases where there's really good triable issues, or there's no agreement, we're going to go to trial on it.
And I've been in Superior Court criminal calendar call a few times, and it's kind of they'll bring in the grand jury indictments, and it's kind of you would sometimes hear people snickering that they'll release 30 indictments, and they've spent 20 minutes deliberating or something along those lines.
Totally. Or 100, and they come back in an hour or two, and the joke is that it's a rubber stamp that every indictment is submitted as a true bill of indictment. It gets bound over. I have seen in my career 2 or 3 of my clients where indictments were not given true bills, and the case effectively gets dismissed. A funny story is my wife got put on grand jury when she was pregnant with our daughter. And so I thought it would be, she would be excluded just because she was married to me. And she's probably hearing cases of people that I represent. But Judge Nobles, who I love, told her, he said, you and Grayson will just have some really good dinner conversations over this year. She ended up getting out after 6 months, but she thoroughly enjoyed it.
Because I would say, grand jury is not a good draw if you get that. Because from what I understand, you have to go, once a month for a year?
So I'll disagree with you there. I think generally people think, yeah, you're going to go once, or I think it's every other week for a year. But the great thing is you're done in like an hour or two.
Yeah, that's
and
right.
so the loser, like the bad card to draw is a murder trial where you're in for months, or a bad med mal case where you're going to be sitting there listening to civil guys hammer it out for months on end. I was trying a 2 or 3 week criminal trial in Brunswick, and a good buddy of mine was next door in the courtroom beside me trying a civil case for 4 weeks. And so I would rather draw the grand jury card and go every other Monday for 2 hours than be stuck. What do you do with your business when you're in a courtroom for 4 months?
Yeah. Now, does grand jury selection work kind of like a jury trial where there's voir dire, or is it just when your number's called, it's your time?
Your number's called. If you don't have a really good excuse, you're going to sit on it. Yeah, the judge doesn't care who you're training with on Mondays, or if you paid for 2 years of that in full. They're going to tell you to figure it out.
Yeah. Well, I know, one of the things I stress to people when they say, they'll criticize the legal system, or they'll talk about something they've seen on the news that upsets them, or one of those things. I always say, well, you should try to do your jury duty. A lot of the times the people that complain about it are the ones that are always trying to get out. Now, that said, do you have any? Do you know any go-tos if you've been called for jury duty that can help you get excused from service?
Don't.
I
mean, I get those calls all the time. Friends, family, acquaintances. Hey, Grayson, man, I've been called for jury duty. I can't do this. Tell me what to say to get out of it. And I'm like, dude, we need you on that jury. Like, more than anything, we need just our peers on our juries. And the last thing, and what it kind of turns into a lot of the time, is I've got 10 of 12 people are retired because they can sit for jury duty and they don't try to get out. And then I've got 2 of my clients, 19 years old. I've got 2 of his peers maybe on the jury. And so my go-to is please don't get out. I want you to at least get in the pool and fill it out. It's not as bad as you think it's going to be.
Yeah. And I know that's one of the things that's a jury's meant to be a cross section of your peers, but the majority of the jury trials I've been involved with have not been what general population looks like. A lot of times it's, you're going to have a healthy dosage of government employees, retired people, and students. Because of those reasons, it's they're not going to put up as much of a fight, or they're not going to have the economic pressure that maybe a small business owner would have that doesn't have paid time off, or that doesn't, they're not facing the same pressure, so they're more willing to serve. But I completely agree with you that the system's only as good as the people involved in it at every level, and it's important to have people contribute their time when they can.
Absolutely, and hopefully that's one of the positives of all of this COVID situation. People are very apprehensive to join into the jury pool because they can't take 2 or 3 days off work. After we've been at this for 6 months, I feel like hopefully people think they can get away for 2 or 3 days, and the house of cards isn't going to fall.
Yeah. And I don't know. I'll be interested to see when the jury trials, or at least the groups of 12. I know I've talked to some guys that are trying cases with 6 jurors spread out amongst the courtroom by consent. But when the full 12 jury trials return, I'm really hoping that we hold out until that time, because I think a Zoom trial would not be effective.
Zoom trial's not going to work. I've seen judges who typically would decline to do a bench trial willing to do that now, which is great. I think in the last 3 months, I've tried 4 what would be jury trials, and I've tried them to verdict. If they were going to be jury trials, I probably would have only done those 4 over the next year. And so we've moved those cases. That's really good for the system. It's good for me, and it's good for my clients.
Yeah. So you're doing the bench trials in person?
We are. Yeah. And I don't have the date on when it changed. It's 2 or 3 or 4 years ago, where a criminal defendant could waive having a jury and have his superior court trial tried by a judge. And there have been, prior to COVID, a lot of judges that take the bench from district court and superior court. And kind of the attitude is, man, I've tried for 20 years trials where it was me deciding. I'm done with that. I'm going to let a jury do it. And so that sentiment has changed because we all want to move these cases. And I tell you, man, I had a 2-day bench trial in Brunswick 2 or 3 months ago now that would have been a full week if it was a jury trial. And because we're addressing issues, knocking them out, we're knocking out what would be a week in 2 days, and we're done, and we're going on to the next trial.
Do you have any preference of trying your criminal matter if it's a bench trial before somebody that's been involved in criminal law, like a defense attorney or a prosecutor, versus a civil attorney?
In terms of the judge on the bench?
Yes.
Yeah. Not supposed to judge shop, but yeah, I mean, you after doing this for so long, you get a sense of who's going to kind of focus in on this detail or that. And if I've got a criminal defense attorney who's turned a judge, I've always liked that.
Yeah. But I guess so. But do you find that? And I guess what I was mainly thinking is the criminal versus civil distinction, because our judges are really asked to handle a lot, especially at the state court level, because they might be doing a murder trial one week, they might be hearing a multi-million-dollar civil issue that they've got to decide without having research clerks or some of the same resources they might have in federal court and other areas. So it's certainly it's a lot to be able to try to manage.
Man, they are tasked with a huge job. To get it right every time they make that call, more so than a referee or an umpire. There's a record of it, and it's going to see scrutiny down the road at the Court of Appeals if it's appealed or even higher up. And having to, for you and me, we have our niches where I'm mainly criminal defense work, and so I know going in what I'm looking at. If you throw me into a med mal case next week, I'm going to flop. And so our judges have to, the book of knowledge that they have to have in terms of how to conduct this trial versus this trial is huge. And they have a huge task ahead of them, and I completely respect them for it. And one of the best things I've seen a lot of, I think our newer judges have done is if they don't know how to make the ruling, they'll take the time to get off the bench and research it and be humble about it and say, I want to get this right.
Who do you find is more anxious to do the bench trial? Is it the DAs to move their docket along, or is it your defendant clients that want their case resolved?
It depends, but there's a lot of apprehension from defendants because they want that judge. Like they think if I get one juror to say no, then it's a not guilty, or it's we're going to try it again down the road. Yeah. And now there's just one person deciding as a jury of 12.
It's less out, I'm sure. Well, we're going to jump back into to discussing kind of the typical plea situation and how that works out when we come back from the break. And if anybody is interested to talk a little bit of criminal law and sentencing and how the system works, please give us a shout at 910-299-7535. All right, we're back on Objection to the Forum with Grayson Cheek. We're talking a little bit about how the plea process works in the North Carolina state courts. And, there's really felony courts kind of where most of the action is and where the most of, I guess, where you have the most to gain or lose with the respective blocks in the sentencing grid. So I want to kind of see if you can take us behind the scenes and what a plea negotiation looks like.
Yeah. So if you can envision, I spoke briefly about it earlier. We never really hashed through it, but like if you're charged with a Class D felony, robbery with a dangerous weapon, and you're in an active block where the judge has no discretion, you're
fixing to go to jail.
You're fixing to go to jail. If you got a lawyer who's up on his current events, he'll know that you could petition for extraordinary mitigation to the judge, and they could switch that active block to a non-active. And that's why you got to always stay abreast of these sentencing changes. But dumb it down here, you're charged with robbery with a dangerous weapon, Class D, you're looking at 5-6 years in jail, and you don't have a defensible case, but you've got a likable client, or they've done a lot to mitigate their circumstances that they're looking at. So that's where I will call the DA and say, hey, look, here's what we've done. We're charged with Class D. We don't want to force this to trial. Will you give us, say, an attempt, like an attempt to rob someone with a dangerous weapon. And in that instance, the attempt would drop that Class D felony down to a Class E felony, which gets us now into a sentencing block where there's an intermediate sanction, and the judge can place my client on probation.
So two things you said that I thought were interesting that I wanted to get into. The first one being, I'd never heard of this term that you used, and I might have probably didn't remember it correctly, but you said an extraordinary mitigation.
Extraordinary mitigation, and this all boils down to like focusing on the sentencing grid, where judges have no discretion other than in the block that they're in. And what I think our trend is that, well, in that instance where there's a first-time offender, I don't want that person to be confined to just an active sentence. That doesn't really do a whole lot of good for anybody, especially if if they're a good person, they did a bad thing, and they're not going to repeat. They're not going to be a recidivist, and so you can apply for extraordinary mitigation, and if you compel a judge to grant that, then the judge can turn that active block into a probationary block.
What's an example of something that could qualify you for an extraordinary mitigation?
Oh man. Falling on your knees and praying and begging, and
so it's really just a matter of
doing 1,000 hours of community service, or doing some really intensive drug treatment if it's a drug offense, or even if it's a non-drug offense, if the underlying. So a lot of these robberies, larcenies, they're all really addiction-driven offenses. Where, look, I'm doing this because I've got to feed this addiction, and if we can nip that in the bud, then now we're not going to do that anymore. And so you just really want to front load these mitigating factors and say, Judge, we've done, 12 things for you, and my client's never been in trouble before. So we're falling on hands and knees and praying, will you give us extraordinary mitigation?
And that makes sense if you're looking at it from that context of look, the crimes happened because of the addiction or because of whatever the underlying root cause is, but that's been eliminated, so you don't have to worry about seeing me a couple weeks later in your court for the next one.
That's right. Put my butt on probation and put an electronic monitor on me, follow me wherever I go. I'm not going to mess up.
Yeah.
Drug test me regularly so that I can prove that I'm on top of the addiction. And so there's no real reason for that person to go to prison for 5 years.
Now, in the plea negotiation context, is that something where you need to have it signed off from the DA, where you're saying, look, I'm going to ask this judge for extraordinary mitigation. I need to communicate your consent or your support to that?
Yeah, I think that's where your plea negotiations maybe have come to an impasse, and the DA is saying, I'm not moving off the Class D or the Class C felony to bring it down. But I'm not, and I'm talking as a DA, I'm not going to budge, but I'm not objecting to you being heard and making your case to the judge for extraordinary mitigation. Because if you've made your case to the DA and they agree, typically that's where you're locking in a plea to a lesser offense.
Gotcha. And you mentioned kind of it could be anything. It could be eliminating the root cause, or it could be dropping to your knees and begging. How much of the kind of the sales pitch, so to speak, is up to the lawyer versus the defendant in these situations?
Everything's probably filtered through the lawyer, but if you've got a defendant who's remorseful and has written letters of apology and is, say, falling on their sword and saying, I did this, I never intend to do it again, and I've corrected my behavior, that falls on the defendant. The negotiation and all falls on the lawyer. And if the lawyer's done a good job, you're going to get there, but you can get there and have it all set up, and you can have a defendant that goes in and presents terribly, that has an attitude, and judges can read that like an open book.
Yeah.
And I mean, I've seen it even with a client of mine where he sucked his teeth after the DA said something in closing argument, and I leaned over to him and said, "Brother, you just put yourself in jail."
Yeah. What's your pep talk or speech to a defendant when you're telling them, look, we're getting ready to go before the judge. We've got a good idea where the sentence is going, but there's some wiggle room here. What do you tell them to prepare for something like that?
I prepare them for the worst, and I think we're getting better. I have a really good idea of what we're going to get, but I'm saying, hey, it could go this way. You just need to stay buttoned up and look respectful, and don't don't make any sharp movements.
Yeah.
Like a defendant making a sharp, like any kind of movement is one thing. Like all the attention is on you. And like if you have a jury in the box and you got 12 people, they are focused on that defendant the whole time. And so if you're slouching back in your chair and throwing off attitude, well, if this guy doesn't take it seriously, why am I? He's right. He's making his own bed right now. He's going to go lay in it.
So what's etiquette in the criminal realm as far as a verdict coming? I've always been taught and kind of employed in my practice, like when the jury's coming back on a civil verdict, we're just going to sit there stone-faced and acting like we expect that to be the result either way. Kind of the example is don't pull the Johnny Cochran, like, yes, yeah, like from the OJ thing. But right. Then I imagine, I didn't just avoid the debt. My client might have won some money or might not have gotten what they wanted. But, I imagine it's a different feeling when you're not going to death row or you're not going to spend the rest of your life in prison. So is it a little bit different in the criminal realm?
It is. It all boils down to what the defendant's personality. Typically, they're a lot more reserved. They understand like that there's decorum in a courtroom, and you shouldn't. I'm not going to give my client a high five. I'm not going to go to him like Maverick and throw him a big five.
Ever do like a little fist pump though, or something like that?
Totally give him a fist bump, or I think I've given many a fist bumps. But if it's a trial that's weighed heavily on them, it's usually you can see this physical ease and like sigh of relief, and maybe a tear or two falls down, and they're like, I can give it up now. Like this is over, and all is well, and then go celebrate later. No need to do it in the courtroom.
A lot of times you'll have what's different in the criminal realm. I think you'll have people's families on both sides. You might have the victims' families watching the trial. You might have the defendants' families. Whereas if you're not going to go watch your son's personal injury trial, if you're not going to do that. But if your son's on trial for murder or serious offense, you probably are going to sit there and watch it, and you're going to be hung on every moment of it.
On every moment, and that's where you see the ones on TV where people faint and call out and praise everybody.
Who do you think? So a lot of times in these crime dramas and these shows, you always see like the overzealous DA, or you'll get the criminal attorney that's a little too loose with the rules. In your experience, who tends to be the more emotionally invested in the cases?
Golly, I think the attorney is
the defense attorney, or
So it depends on the type of offense. Prosecutors that have to walk with crimes of sex offenses, I can't imagine having to try those cases week in and week out, and to have to talk to a young child about things that might have happened to them. At that point, I feel like maybe the person that's been involved with the victim is going to be way more emotionally invested. And I mean, the defendant's emotionally invested. And it depends. Like the facts of the case are all different. But I feel like typically as a defense attorney, we're walking with our clients through their darkest hours, and we're dealing with their biggest problem day in and day out. And so when it comes to a trial setting, the state does not have much to lose. Okay. They're not going to prison, or they're not going to be fined bunches of money or lose rights and privileges. And the defendant is. And so there's a lot more invested on the defendant side and in what I'm doing to help them than I think on the other. And that's not to short a prosecutor, because we've got tons of great prosecutors here, and they do a knockdown job. But I would say that I think the defense attorney, and sometimes more so than the defendant even, is more emotionally invested in the case.
Yeah, and I guess because there's the whole thing of there's the remorse of what could you have done differently, or there's always that thing that I think everybody goes through of, well, now that my client's in jail, and it's a lot to deal with. And I guess especially if you're from the prosecuting standpoint, you can just say, well, we'll get them the next time, or something along those lines. But I know they care about it, as well, and it's a emotionally charged area.
Yeah,
so
for the state, it always. And it may not be the case, but it always seems like it's more of a hypothetical, because there's no repercussion at the end of it, so much as there is for the defendant. Yeah.
Well, we're getting ready to go take a break. Anybody wants to call to talk to Jason, 910 299-7535, or Grayson, I'm sorry, I said
That's all
Jason.
good,
Grayson,
Clients have called me worse.
299-7535. We're gonna get into advanced supervised release, which I think that's something that you're on the forefront of. It's a new situation that a lot of people don't know about, so I'm excited to learn about this. All right, back with Grayson Cheek from the Cheek Law Firm. Grayson, I'd like to spend the last segment this evening talking about ASR.
Yeah, man. Touching back on how with structured sentencing, where our judges and we're all confined to these blocks on the sentencing grid. The Justice Reinvestment Act in 2011 introduced then something really novel for us, which it's called advanced supervised release. And it, in effect, was a way for judges to be able to grant an active sentence that's outside of the block. And I did a case in Mocksville. It was probably 2011, 2012, right after advanced supervised release came out. And it was an attempted first degree murder case, a couple of counts. And I was able to negotiate it down to a Class D where my client was looking at an active sentence. And advanced supervised release allowed me to take what, in effect, with his prior counsel was a 24-year plea and turn it into about 6 years. And what it looks like, I guess I should get into that. Advanced supervised release it's a program that's introduced or run through the Department of Corrections, and the inmates that are enrolled in it take classes, and they enroll in this program that is aimed at reducing reoffending rates.
Well, let me see if I understand. So this is different from extraordinary mitigation.
It is. It's another avenue to break down the time.
Is it kind of like, so you said that there's an ongoing obligation of the defendant during their active time?
There is. When you're looking at a sentence of, say, 20 months, your bottom range is going to be 20 to 25 months. And your DA is not giving you a mitigated sentence because they're not putting their name on mitigating that sentence, say down to 15 months. You can ask for advanced supervised release, and as long as the DA doesn't object, the judge can order it. And so that, say you're at 20 to 25 months, what advanced supervised release does, if you're sentenced in a presumptive range, that drops you to the bottom of the mitigated range. And prior to ASR, if you were sentenced, say, at the bottom of the mitigated range and it's an active sentence, that's the number that you do when you go to prison. And it's honestly a little bigger. So let's say it's 15 to 21. You take out 9 months of post-release supervision. And so you're like 15 to 16 months. You're going to go in and do 16 months and work your way down on gain time. Advanced supervised release gives you a hard release date. And so you don't have to get gain time while you're at prison. You're going to get out. If I say you're going to do 15 months, you're going to do 15 months and get out, so long as you complete the program or you don't complete it due to no fault of your own. And I'll touch back on that. That can be really useful with someone that's been incarcerated pre-trial. Or if you're sentenced in the mitigated range, let's say you're at 15 months, the DA's giving me the best deal they can give me is bottom mitigated 15 months. Well, advanced supervised release then allows the judge to give you a release date that's at 80% of that minimum sentence. And so 15 months, the corresponding minimum is going to get you down to 12. And so, go ahead.
Is there any kind of standard you have to meet to qualify for ASR, or do you just have to know to ask for it?
You got to know to ask for it. And really, that's something you've got to negotiate with the DA, because all it takes is a DA to say, I object, and you're not getting it. It's written into the law that if a DA objects to it, the judge can't order it.
Yeah.
And so that's in my negotiations with the DA. I'm like, look, I'm going to ask for ASR. And I've had a lot of them come around to really like it, because there's a heavy back end to ASR. You're going to get out earlier, but you're going to be on a longer post-release supervision period. And if you screw up 3 times, you're going out and you're going to do your full maximum sentence, which can be longer than if you were to do it the other way around.
What do you mean by if you screw up 3 times? Is that if you screw up when you're on your post-release supervision? That's
right. When you get out from your active sentence, you still have this longer active component that's your top end that you're sentenced to, that you work your way down when you're in prison. And that includes that 9 or 12 months of post-release supervision. And if you get out and you're reoffending or just screwing up, they can send you back for periods of confinement. And with ASR, if you do 3 of those, 3 strikes and you're out, you're just going to stick there and not do any more post-release supervision. You're going to go do a longer term because you're going to go straight to your maximum and not get your game time.
Well, I imagine that's a big discussion you have to have with your client as well when you're pushing for that, because it'll save you some time. But I guess they need to be aware of the
repercussions. Yeah, because it can go bad. But the whole goal of the program is to reduce recidivism. And so really, when you're talking about somebody that is incarcerated or is going to be incarcerated, that really focused on that front number.
Yeah.
When am I getting out?
How does post-release supervision compare to probation?
Really, it's really similar. I've never been on either.
Yeah.
It's very similar.
Gotcha. What do somebody that's pled guilty and has got a ASR sentence, what are the obligations while you're confined or when you're in prison? What do you have to do as part of your sentence?
It's classes, and I think it's just a different program of classes. Hey, you're going to go do some studying on this, and we're going to do some literature here. And as long as you go to what they say to go to, and you don't commit crimes while in prison, you should graduate.
Yeah, I was gonna say. I mean, if you're in jail anyway, why not do it?
Totally. The main reason is because an assistant DA has objected to it, or a judge has not ordered it. But it's been a really good, useful tool to say, let's talk. Like, I've got a client and we're ready for trial. My client's been in custody for 12 months. Okay. And we're on the heels of a trial. We've got a victim that does not want to testify. I'm already working with 12 months of credit. And he's looking at, say, 4 years in custody at trial and losing. Well, there's some incentive for the DA when they have a witness that's not cooperating to say, all right, let's work this out to a plea. And if we do it standard without advanced supervised release and we're working with that 12 months credit for time served, well, if you do that, the Department of Corrections is going to say, well, he's got 12 months, but really this is like a 12 to 14 month sentence. And so now we've got to process him through. And because he's been in the local jail, he's not done anything to get his what we call gain time. Like good behavior breaks your 14-month sentence down to 12. Mm-hmm. Advanced supervised release gives us that hard release, what I call a hard release date, at 12 months. And so that's a matter of DOC not saying, well, you don't have your gain time. We can't let you out yet. You got to come up and spend a couple months on a camp. They can say, well, you've got the 12, ASR, you've not completed it through to no fault of your own. And so your hard release date is 12 months. Now all we have to do is send the processing paperwork back and we'll release you from jail.
How much say do you typically find that the victims have in a prosecutor's willingness or reluctance to consent to ASR?
The prosecutors have a duty to inform the victims along the way and to let them know of what they're offering in terms of a plea. And I think that reasonable victims have a lot of say-so.
And is counsel for the defendant, is there anything that prohibits you from speaking with the victims? I mean, I guess to the extent they're a witness, it can help, but a lot of times they probably don't want to talk to you.
Yeah, I think it's just community morals, Nothing's saying I can't talk to a victim. There's plenty of laws that say, or bond conditions that say my client can't. But I try to talk to them through the assistant DA on the case. But there are times where I have victims ringing me up saying, look, I need to talk to you about this. I don't want to proceed.
Yeah.
Yeah.
And I guess that becomes a problem, because I'm sure the DAs don't want to hear it when you're the ones telling them, look, your witness doesn't want to move forward. You need to either cut a deal or let's drop this.
Yeah, I think we all get jaded to that kind of behavior. It's seen a lot, especially in domestic situations.
Are there any limits on types of cases where ASR can be used?
Yes. So they are limited on that block, the sentencing grid, to Class D levels 1, 2, and 3, and then it stair steps down. So E level to 4, F to 5, G and H to level 6, I believe, and I. So actually on the I don't think, yeah. So it stair steps down, but it starts at Class D levels 1, 2, and 3. So that case that I had in the western part of the state, that was the couple counts of attempted first-degree murder. He was a Class D level 2.
Level in the level.
So
how
he
many
was
priors?
right in the block, and ASR had just come out, and I'm talking to the DA up there, and there was a co-defendant in the case and co-defendant's lawyer, and we're really on the eve of pleading. And I said, guys, look, there's this new thing out called ASR. I'd never done it before. And I told the DA, I was like, Rob, look, I think this would be beneficial here. You've given me an active sentence in a Class D block. This ASR, if my guy screws up and doesn't do it, then he's going to go pull a longer sentence than what we're talking about. But if he does well, I think we all win. I had a pretty sympathetic victim there. And so he was game. And so my guy ends up cutting his sentence down very significantly.
Well, it's interesting to hear how that works, and it kind of makes sense what you're saying as far as the where maybe if we're talking murders or your Class A, B, C felonies, it's like, we don't want to get into a program like this, but it makes sense how you've kind of explained it with what's eligible for it. Well, Grayson, I appreciate your time. I've learned a lot today. If you have any criminal defense needs, you caught a case, please give Grayson a shout, and I look forward to seeing you again.
Yeah, man. Thanks for having me on. It's a lot of fun.